62B District Court is now in session with the Honorable Amanda Sterkenburg presiding.
Hey, Deputy, I am still short one MIDC attorney. Do you have any information on where Mr. Howard might be? Was he taking a long lunch?
I'm not sure, sir, Your Honor. I will attempt to get a hold of him.
All right, we're going to address a matter here in the courtroom.
Yes, ma'am.
The court is calling the case of the City of Kentwood versus Layla Marie Jr., case number 21-502510T. Ma'am, you can come right up here to the lectern. Ma'am, I'm Judge Sterkenburg. You have come to the court today, I think, trying to reschedule a matter. Is that correct?
Yes, please.
All right.
Possible.
So your matter is set for a pretrial conference on May 26th at 3:15 in the afternoon, and you indicated to me that that is your high school graduation?
Yes, ma'am.
Well, we don't want you to miss that. I also don't want you to proceed and admit any responsibility unless and or until you've had the opportunity to meet with our city attorney. So here's what I'm going to do for you. I'm just going to adjourn this pretrial date. We'll set you up with another date that's after your high school graduation. You can come back and it won't be a problem for anyone, okay?
Thank you so much.
You're very welcome.
Am I good to go?
Not quite yet, because I'm gonna have my clerk generate a date for you and she'll give it to you before you leave.
Okay.
Let's see.
Your Honor, I just spoke with Mr. Howard. Apparently he wasn't aware what time the court started. He said he's logging in right now.
Mr. Howard, okay. And I assume this is your original name.
Yes, ma'am.
There you go. Say good luck. Congratulations.
Thank you.
Good afternoon, Mr. Howard. You're muted.
Okay, how about today? Am I here now?
You're here now. Were you taking a long lunch?
I guess so. I'm sorry. For some reason I had it in my mind today that we started at 1:30, so that's on me.
That's okay. You're here.
To be quite honest with you, Judge, I don't know what happened. I've been doing this a while, so I should not have made that mistake. But
Well, I'm here. You're here.
yep, sorry.
We're
I
good to go.
apologize for being late.
The court is calling the case of the state of Michigan versus DeAndre Andrew Murphy, case number 21-60124FY. You are Mr. Murphy out at the jail?
Yes, ma'am.
All right, Mr. Murphy, I'm Judge Sterkenburg. You are here for arraignment. Arraignment is your opportunity to hear the charges being brought against you and your rights as they relate to the charge. The state of Michigan alleges that on or around April 11th of this year in the city of Kentwood, county of Kent, you committed the offense of assault with intent to do great bodily harm less than murder, which is a felony punishable by up to 10 years in confinement and a fine of $5,000. It is further alleged that on the same date and time, you committed the offense of weapons, firearms, discharge in or at a building, which is also a felony punishable by up to 10 years in confinement and a fine of up to $10,000. It is also alleged that at the same time, you committed the offense of carrying a concealed weapon, which is a felony punishable by up to 5 years in confinement and a fine of $2,500. Do you understand the charges and their maximum criminal penalties?
Yes.
All right. The court has received a felony advice of rights form signed on your behalf, and so you had an opportunity to speak with an attorney regarding your rights, correct?
Yes.
You understand your rights?
Yes.
One of your rights is the right to an attorney. If you cannot afford an attorney, one may be appointed for you. Are you asking the court to appoint an attorney to represent you on this matter?
Yes.
All right, we'll send some paperwork down to court services for them to make a determination as to whether or not you qualify for a court-appointed attorney, and if so, whom to appoint. On each of these counts, we are going to say not guilty today. They're felony offenses, sir. You can't proceed without an attorney. Mr. Howard is here for the purposes of arraignment only. It's limited scope representation. So we'll say not guilty, and we will schedule you with 2 appointments to come back before the court. The first is a probable cause conference set May 27th at 9 o'clock in the morning. The second is a preliminary examination set June 7th at 3 o'clock in the afternoon. The purpose of these hearings is for the state to prove that there is probable cause to believe the crimes charged were committed and probable cause to believe that you are the individual who committed them. The last thing the court is going to address is the matter of bail. Bail is set based on a number of different factors, including risk of flight, risk to public safety, your prior criminal record, if any, including any failures to appear, and the severity of the offense charged. Mr. Howard, I do have a pre-sentence court services report, not a pre-sentence report, a pre-bond report, which indicates they are recommending no PR bond with supervised release as the nature of these charges is violent. The defendant does not live within the Kent County area, has prior assaultive charges, and community safety is a concern. That being said, I'm happy to hear any additional comments that you may have on behalf of Mr. Murphy.
Thank you, Your Honor. I did speak with Mr. Murphy this morning. He gave me permission to sign his name to the advice of rights form, and we covered those rights. I did speak with Mr. Murphy, and he told me that he lives in Galesburg. I provided the court with his address and telephone number. He lives at that address with his girlfriend, who's the mother of his child. I also believe he lives with his mother at that address as well. He is originally from Chicago. He has lived in Kalamazoo since 2017, and he's been at that Michigan Avenue address in Galesburg for the last year. According to him, he is attending high school online. He is not working because of COVID. I do understand the seriousness of the charge, Your Honor. He doesn't have any, according to him, any other pending charges. In terms of a prior record, he had a domestic assault or domestic violence for which he received HIDA. So I don't know that he has any serious record at all. I don't know anything about the nature. I understand the nature of the crime, but I don't know anything about the exact details of the crime. I understand the court's concern about the seriousness of the crime. I would ask the court, in whatever bond it decides to set, to require him to report to court services, and beyond that, Your Honor, I guess I'm asking for a 10% bond if possible, so that if the family can post a bond, they would at least be able to use it towards the resolution of this case. Thank you.
Thank you, Mr. Howard. Mr. Murphy, are there any comments that you would like me to take into consideration before I set the conditions of your bond?
Yes. So basically, what I was talking about with the domestic, basically, like I said, in 2019, my ex-girlfriend, we had got into it or whatever, and I had walked.
Hold on, is the offense for which you were given HIDA?
Oh, yes.
Were you successful in completing your probation?
Yes, I came to every court day. I paid all my fines off. I made sure everything was good so I get back home to my family.
It's about that date. I want to know about what you're doing right now as it relates to whether or not I can trust you to show up and stand trial on these charges.
What I'm doing now, specifically since the thing had happened, all I've been doing is just sitting at home with my daughter. And, making sure everything good. Like when they came and got me yesterday, I told my girlfriend, I'm like, hopefully, everybody see that I wasn't, guilty for the situation. I was trying to protect my life and come back home. But
Sir, 21 years old, but you are attending high school online.
so basically, I came from Chicago and I was going to school, whatever, doing my thing. Then when I had got, in trouble, it had kind of pushed me back a little bit. So I had went back to go do my thing online at Kalamazoo Covenant Academy. It's basically like from people who are all the way up from 15 up to 22 to get their high school diploma. And I talked to my mom about it, and I had went back so I get my high school diploma to prove. But right now, I'm still attending in school as we speak.
Right. The affidavit of probable cause in this matter, sir, indicates that you concealed a firearm inside of a motor vehicle, that you had it on your person, that you discharged it inside Dave & Buster's restaurant. That is the allegation in the affidavit of probable cause. And I'm familiar with this restaurant. And for better or worse, it is a place where families take their children. And you have a daughter. So I'm certain you can understand the court's concern about the gravity of the allegations here and how, while it indicates there was only one victim, there could have been, if any of this is true, a number of victims, including minors. And I have significant concerns about public safety in this situation.
Yes, Your Honor. Speaking on that, when that situation had went on.
Situation, because anything you say, as Mr. Howard told you, can and will be used in a court of law. So this is what I am going to do. I am setting bond at $75,000 cash at this time, sir. If you are released from the Kent County Jail, you must show up on time for all court appearances. You may not leave the state of Michigan without the court's permission. You must keep us notified of your address. You may not commit any crimes while out on bond. You may not be on the premises of any Dave & Buster's restaurant. You may not possess or purchase any firearms or ammunition or any dangerous weapons.
Okay.
You are not to have any contact with the alleged victim in this matter, Devin Faust, in person, in writing, by telephone, by text, by email, by social media, or by a third person. You are not to consume or possess any alcohol or marijuana or drugs unless prescribed by a physician. You may not misuse prescription drugs or be in the presence of anyone using illegal drugs. I will require you to report to court services if you are released at 180 Ottawa Avenue. That is the courthouse downtown. Kent County Courthouse, Suite 2100 will send you their address and phone number so you can be in contact with them, obtain any counseling or substance abuse assessment that they require, submit to any test as they require. And if you are released, I'm going to require you to be on a GPS tether. Sir, I will revisit upon motion the conditions of your bond at the probable cause conference once you have counsel. But for now, I simply I cannot risk this community's safety to do anything less than the $75,000 cash bond. You're all set with me today. Thank you.
Thanks.
I think that's all I had with you, Mr. Howard, or are you here with Mr. Thornburg also?
Well, I have interviewed Mr. Thornburg, Your Honor, but I do see as an attorney, Mr. Houghton or Miss Houghton. I don't know. I'm not familiar with that attorney.
Well, that would have been Zachary Houghton with the Defender's Office, who has been replaced in his position with this court by Kurt Oberholzer with the Defender's Office. I do see that Mr. Thornburg was already arraigned on one of these charges, and then the second, he never made it even to arraignment. So you're welcome to stay since you've already met with him.
I would be happy to do so, Your Honor.
All right. We will start with State of Michigan versus Thomas James Thornburg, case number 20-30285 ST. In this case, sir, the state of Michigan alleges that back on October 16th of 2020, you operated a vehicle in the city of Kentwood while your driver's license was suspended, revoked, or denied. That is a misdemeanor. It is punishable by up to 93 days in jail, a fine of $500 plus court costs and collateral consequences, such as Secretary of State penalties. You were arraigned on this matter previously back in December of 2020. And every time we have scheduled you to do something, you have failed to appear. January 25th for a pretrial conference, March 22nd for a pretrial conference, April 18th for a pretrial conference. In fact, I see 2 bond slips in here indicating to me that you've posted a bond at least before in this matter and then still failed to appear. Where have you been?
Ma'am, I've only been, I don't know what you mean by arraigned. They told me they set one court date for me before and I did miss it. They brought me in and set another one. And then I was in the hospital. I was hospitalized. I had a surgery for a cyst on my testicle in Kalamazoo, Michigan at Borges.
When were you
So
hospitalized?
I don't know the exact date. I know it was the date that I was supposed to be in court though, because I was freaking out in the hospital. But I did miss court and I don't recall being arraigned. I guess I don't know exactly what arraigned is. I'm not super, everything has gone together for these charges. There was actually 2 charges. There was this one and then the false ID one, and they've been going together every time.
Right. So I do have the second one here. And you're correct. It's not a new charge either. That's case number 20-50509 OM. Wherein, as you stated, the city of Kentwood alleges that you provided false information to a police officer, which is a crime punishable by up to 90 days in jail, fines, and cost. And similarly, you failed to appear on January 20th, March 17th, and April 3rd in this matter.
Yeah,
Arraignment is a hearing wherein you are read the charge and the maximum potential penalties, which you have just heard in each of these cases again, and which you heard from me before, and which you heard from my predecessor before that.
Yes, ma'am.
So I don't know when exactly you were hospitalized, but I know that you need to get these taken care of. And if you were in fact hospitalized, at some point you got out. I doubt they took you from the hospital to the jail. Did they?
No, they did not. Nope.
Why didn't you contact the court?
I was afraid that because I missed it, that it was going to be more of a punishment. I was scared. Like these charges aren't a big deal to most people, but to me, any charge is a big charge, you know?
All charges are big charges, right? They are important. They impact your future, right? And the way
Yes, ma'am.
lawyers and housing agencies perceive you, it is a big deal.
Yes, ma'am.
How did you get picked up?
I got picked up in Eaton County. In Eaton County, I got picked up.
Okay. Do you have charges that you're facing in Eaton County?
Yeah, domestic violence. Well, I don't know if they're actually picking it up or not. Like, they showed up to my hotel room investigating a domestic, and there was nobody there. It was just me. And they ended up, once they ran my name, it didn't matter anyways. Like, once they ran my name, I had the warrants, and it didn't really matter about the domestic. They just took me to jail.
Well,
They did set a bond in Eaton County for me, though.
as to the domestic. I will set a new bond on each of these cases. I'd be pleased to hear your comments.
Excuse me, was that for me or Mr. Howard?
Mr. Howard, I'd be pleased to hear your comments as they relate to bond.
Sorry, Your Honor, I didn't hear that. Your Honor, I did speak with Mr. Thornburg. I provided the court with his address in Pittsburgh. He related to me as he related to you that he was getting treatment for a medical condition. Having missed the court date, he panicked and didn't deal with it. I asked him where he was now, and he indicated he was in jail. And I explained to him that probably would have been a better approach to contact the court and let him know he was in the hospital, which he agreed with and understood. And he was sorry done what he did. Your Honor, these are misdemeanor charges. They're driving offense charges. I'm not going to downplay them as not serious, but they're in the spectrum of criminality. They're at the lower end. I would simply ask the court to consider a bond, a low bond, perhaps a 10% bond. He's not employed at the present time. He's receiving unemployment benefits. I do believe he will deal with these things. I think he wants to have a pretrial conference and see if he can work it out with the prosecutor's office. So he's sorry for having missed it. He knows he was wrong to do so. He's essentially asking the court for a second chance, as am I. So I defer to the court as to what's a disposition or what's a fair bond for him. He certainly has violated the terms by not showing up like he should have. And all he can say is sorry. So with that, Your Honor, I defer to the court.
You, Mr. Thornburg, is there anything else that you would like me to consider before I set conditions of your bond?
Just as that, I am sorry. I realize the seriousness of the charges. My birthday is coming up on the 26th. It would be nice to not be in jail for my birthday. I don't really have much of an income right now. A PR bond would be amazing. I know that I've done you wrong on that note before, but I would really appreciate another chance, like Mr. Howard said. And I won't let you down.
The advice of rights form that Mr. Howard sent over gives a Vicksburg address, not the most recent address that we have on file for you. Is that where you are living and receiving mail?
Yes, ma'am. Vicksburg, 620 West Prairie Street. 620 West Prairie Street in Vicksburg, Michigan.
He also has an email address, Your Honor. I don't know if he wants to provide that to the court or not.
So
Yes, ma'am.
we are broadcasting live on YouTube right now. If you provide me your email address, it will be out in the public for the public to do with it what they will. You may give it to me and I will put it in your file and you'll get email notifications of your upcoming court dates, but you're not required to because it is a non-public record. And so if you would feel more comfortable, you can contact the court at another date. And give that
I would love to give you my email address if it gives me another. Yeah, let's go. It's doofgod13, DOOFGOD, doofgod. The word dog food backwards. It's an old high school nickname. 13@gmail.com.
DOOFGOD
1. Yep. Doofgod.
13 at what?
Gmail.com. Gmail.com. Yes, ma'am. Sorry, you're breaking up over here a little bit.
Okay. Sir, you didn't just do me wrong on a PR bond. You did yourself wrong because
Yes, I did.
you were given a PR bond way back at the get-go by Judge Kelly. And you failed to appear. And a bench warrant was entered. You came in, you were arraigned, it was reduced to a PR bond. At some point, you paid a bond, which was forfeit. I'm going to set $200 cash bond on each of these, sir.
Okay. So that would be 400 total?
That is 400 total. If you are released from the Kent County Jail, you must show up on time for court appearances, remain on without the board's permission. You may not commit any crimes while out on bond. You must keep us notified of your address. No driving without a valid driver's license. You are not to possess any firearms, ammunition, or dangerous weapons, and you are not to consume or possess any alcohol, marijuana, or drugs unless prescribed by a physician.
Okay,
That's it, sir. You're all set for me today.
thank you.
All right, thank you, Your Honor. I believe that takes care of us. Have a good weekend.
I think that's all. Thank you. You as well.
Your Honor, I would move to withdraw.
Your motion is granted. You may be released from these prior matters of limited scope representation.
Thank you, Your Honor. I hope you have a nice weekend.
Thanks, you as well. We'll see you next time. Don't be late.
I won't be. I'm sorry.
All right, thanks. Goodbye.
Yeah, bye-bye.
B District Court is now in session with the Honorable Amanda Sterkenburg presiding.
Good afternoon, everyone. I have someone appearing as LG Stylo 5 on my screen. Ma'am, I don't know who you are. Can you unmute and identify yourself for the court?
Rosa Evans?
Ms. Holtzlander Evans?
Yes.
All right, the court is calling the case of Wingate Apartments versus Ateria Trimble, case number 21-3405 LT. Ms. Trimble, I see you on my screen. Do you have a camera that you can turn on, and can you unmute yourself?
Yes.
Hello, ma'am.
Hi.
All right, Mr. Groendijk, you appear on this matter? You are muted still.
Sorry. Yes, I am here for the plaintiff. Good afternoon, Your Honor.
Good afternoon. This is the second hearing in 2 landlord-tenant hearings. We call these summary proceedings, ma'am. You did not appear at the first hearing, which was back on, looks like, what date was our first hearing on?
Last week, Friday.
The 14th?
14, which is back on May 14th, and I don't have any notes that indicate that you appeared. The court was given information that rent to retain possession in this matter was $1,783. Ma'am, do you have any reason to believe that that information is incorrect, that the number is wrong?
No, that's correct.
All right. You have a number of rights, ma'am. Because you weren't here before, I'm going to quickly go over them with you.
Okay.
In landlord-tenant court, you have the right to have a lawyer represent you. The paperwork you received should have indicated how you can contact lawyer help. You may contact Legal Aid of Western Michigan or the Grand Rapids Bar Association Lawyer Referral Program. You can visit the Legal Assistance Center here at the 62B District Court. This is the second hearing, and so a judgment may enter today. If a judgment enters, you will have 10 days to pay the rent and court cost, to move, or to appeal this court's decision.
Okay.
COVID emergency rental assistance may be available to you. Assistance may be obtained through the local coordinated entry agency or housing assessment resource agency, HARA, from the Department of Health and Human Services or Federal Help for Homeless Veterans. Lastly, if it appears appropriate to this court, the matter may be set for mediation or trial. You said that you don't dispute the amount of rent that's due and owing. Is there any reason that you haven't paid other than you just don't have the money?
Not the money, and the end of my lease is on the 31st at the end of this month, so I kind of have to prepare to move somewhere else.
All right, have you made arrangements to move somewhere else?
I'm gonna kind of, not 100%, but I know I gotta get out of here, so
Have
kind of gonna
you
be.
applied for any financial assistance?
No, I actually contacted them to try to come up with some type of payment arrangement because I know I still owe them at the end of the day. But they said they weren't able to do that.
All right, are you working?
Yes, I'm working.
Were you aware that there was assistance available through the Department of Health and Human Services or through Sarah?
No.
All right, Mr. Grondek, how are you asking the court to proceed today?
Your Honor, we'd ask that the court enter a possession judgment in the amount reflected in the statement of rent.
All right. Ma'am, as you don't dispute the amount due and owing, the court will enter a judgment today in the amount of $1,783. That means you have 10 days to move. Or to dispute this court's decision, or to negotiate through paying the rent some kind of extension with your landlord. What I'm going to do for you, ma'am, is I'm going to enter this judgment, but when we close your matter today, I'm going to put you into a breakout room with Helen Hampshire. She's my representative from the Department of Health and Human Services, and she may be able to assist you with resources that are available for rental assistance at this time. Mr. Grondek, I don't have a proposed judgment in this matter.
Oh,
So if you want to send one over with a writ date of June 1, we'll get it entered.
we will do that, Your Honor.
Thank you. All right, Ms. Trimble, watch your screen. I'm going to give you a breakout room with Ms. Hampshire, okay?
Okay, thank you.
Right, the court is calling the case of Short South Realty Group versus Rosa Holtzlander Evans, case number 21-3398LT. Mr. Sutherland, you appear on this matter, correct?
Yes, Your Honor. Good afternoon. Attorney Kevin Sutherland, PA 1681 on behalf of Short South.
Good afternoon, and you are Ms. Holtzlander Evans, correct?
Yes.
All right, this matter was set for the second of 2 hearings in a summary proceeding on a complaint to recover property for non-payment of rent. When we appeared at the first hearing, ma'am, you did contest the amounts due and owing. And I think we're given some other information, amongst which was the suggestion that you check the ledger with your landlord. And so I'll ask Mr. Sutherland if there have been any updates in this matter.
There have, Your Honor. I think yesterday afternoon I did receive defendant's written answer, and I appreciate that one was attempted. It would have nice to see legal aid, I think assist a little bit more on this one. There are some slight defects that would be really helpful in terms of housekeeping for this court to go over that answer. But I think at this point, procedurally, I believe we're just going to set this for your soonest available trial date so I can bring in maintenance and bring in the property manager and so forth and see if we can resolve it that way. But on the answer, Your Honor, at a time that's available, I'd like to go over just maybe 3 of the items to confirm what's been written.
Do you want to go over that on the record, or do you want to go over that with Ms. Holtzlander Evans?
On the record, Your Honor, just because that'll be sufficient, I think, to cure some defects that may have been inadvertently provided. If I may proceed on that.
You may. I don't see any other tenants waiting on other matters that are scheduled this afternoon. And so, Mr. Groendijk, if you can just sit tight on the other matters that he is waiting on, we can't proceed because we don't have all parties. So, Mr. Sutherland, please go ahead.
I appreciate the court's patience on that, and certainly I will be very brief. I just wanted to confirm paragraph 5 in the answer related to the amount owed. She stated rent was lowered to $1,283. I just wanted to clarify, is she suggesting that Mishta should no longer be paying $1,450 and that Mishta should be paying $1,283?
Yes. In January, we ended up finding out that the home that I am renting is not a 4-bedroom, a legal 4-bedroom. We ended up finding out that it is only eligible for 3 bedrooms out of the 4. At that time, Mishta spoke to John Clark and told them that they couldn't continue to pay for $1,450 because it wasn't a 4-bedroom legally.
Okay, that's fine. That's sufficient. I appreciate that information. Just want to clarify that that if there was any payments coming in for $1,450, obviously any of those credits that were beyond $1,283 would have to be kind of figured out which one's your portion and which ones that Mishta may have credited. Your Honor, I appreciate your patience. There's no specifics on our paragraph 7 saying the property has not been making repairs. In Michigan, every landlord has a right to reasonable notice as to when some repairs were done. So I think what I would just ask, if it's possible, Your Honor, to get a checklist or order that the move-in checklist that's required in all landlord-tenant proceedings just get provided to us so we can see what was disclosed at move-in. Is that possible?
I actually didn't get a 7-day check-in with the COVID and everything going on. It was something that got emailed, but I was never able to give it back to them. But in the packet that I dropped off to you, there is an email in there that says everything that was wrong with the property when I moved in. It should have been dated.
I appreciate that. So we can get into all that trial. I'm not trying to litigate today. I just want to make sure from my notes. So you did receive a checklist, but you didn't have a chance to return it. Is that correct?
Right.
All right. Thank you for the clarification. Last but not least, you said in paragraph 8 that you disagree that defendant has not complied with demands made. So I just want to be clear that we had issued a demand for possession on April 5th in the amount of $643.73. You said you had disagreed with that. Are you stating that you had paid that amount for any reason?
No, I'm just disagreeing with the amount, and basically it's saying that it's rent when it's not rent that's owed, that it's maintenance issues and stuff that it's owed.
Thank you for that. And Your Honor, thank you. That's all I had to clarify on the record, and we'll just look for the trial date at your convenience.
All right, we will do that. Ma'am, I think that I gave you opportunity to speak with Mr. Henry from Legal Aid, didn't I?
Yes, I did. I've spoke to him. We've been working back and forth. I actually Was in the hospital from Sunday to Monday due to pulmonary embolisms in my lungs. I got out Wednesday, and then I had to go back Wednesday, and then I got out Thursday. So that's why everything got dropped off late. I wasn't able to get everything turned into him, but I have been speaking to him and everything. He's giving me heads up on everything. I filed a SCR just in case. My DHS worker said that it could take up to 7 days. Hopefully that'll help solve everything going on with the money situation. But I've done everything that he informed me I should do.
Did you file a CDC declaration or a SARA application or both?
I filed a SER with DHS, and I also filed I don't have the paper in front of me, with Salvation Army.
Okay. So if it's with the Salvation Army, then you filed a SARA application, which means, Mr. Sutherland, that we have to stay proceedings at least 30 days regardless. So that trial date will have to be outside of probably the 45-day window.
I agree with that, Your Honor, under the current orders. Thank you for bringing that to the attention. It does sound like she did also sign up through state emergency relief funds, SER funds through DHS. So that's great that she's got plan A and plan B going. I appreciate that.
Okay, so we will get a trial date. We won't be able to get a notice generated and out to the parties until next week because Jennifer is off today. But we will get that out to the parties, and we'll see what we can resolve between now and the trial date. Perhaps legal aid will file an appearance and you will be able to work this through.
Thank you.
All right,
All right,
thank you.
thank you.
Evans, do you have any other questions for the court?
No, I don't know at this time. Thank you.
All right, you may go. Thank you.
Thank you for the court's time, Judge. Have a great day.
Yes, you as well. All right. The court is calling the case of Wingate Apartments versus Larry Phillips, case number 21-3402 LT. Counsel, your appearance for the record.
Randall Grundig for Wingate Apartments.
All right, Mr. Groendyke, this is the second hearing in this matter. We were here back on the 14th of May, and it looks like that was just last Friday, and the tenant failed to appear. The court was given information that rent to retain possession was $2,265, inclusive of court costs. Are you seeking a default judgment today?
We are, Your Honor.
All right.
Possession judgment only. And Mr. Hendrickson from Wingate is, I believe, connected here as well.
All right, Mr. Hendrickson,
I'm here.
are you able to turn on your camera?
I do not have it on my computer.
I think I knew that, but I'm going to continue to pester you until you do.
That's fair.
All right, I guess I'll have to believe you that you're raising your right hand. Do you swear or affirm, Mr. Hendrickson, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Groendyke, you may inquire.
Thank you, Your Honor. Would you state your name, full name for the record, please?
Full name Jeffrey Hendrickson?
And are you employed by Wingate Apartments?
Yes.
Are you familiar with the lease between Wingate and this tenant, Tori Phillips?
Yes, I am.
And is the amount submitted in the statement of rent to the court of a balance to retain possession $2,265?
Yes, it is.
And that would be through the month of May.
Yes.
And are you requesting possession judgment in that amount?
Yes, we are.
Was this apartment kept in a reasonable state of repair and fit for the purposes intended?
Yes.
To the best of your knowledge, is this tenant under the age of 18 and the military or incompetent?
Not to my knowledge, no.
And have you received a SERA application from this tenant?
No.
And have you received a CDC declaration from this tenant?
No.
Thank you. No further questions, Your Honor.
All right, there was a proposed judgment here. I filled in the amounts as testified to. This will enter as a default judgment with a writ to enter after June 1.
Thank you, Your Honor.
You are welcome. Give me just a moment. The court is calling the case of Wingate Apartments versus Deodra Taylor, case number 21-3404 LT. Mr. Grondike appears on this matter as well. Do not see Ms. Taylor. She failed to appear at the first hearing, which was May 14th. At that time, the court was provided information that rent to retain possession was $1,730.99. Is that still accurate, Mr. Grondike?
As far as I know, Your Honor. Jeff?
Yes, that is still accurate.
All right, and are you seeking a default judgment today then?
Yes, Your Honor, default possession judgment.
All right. Mr. Hendrickson, you are still under oath. Mr. Grondike, you may inquire.
Yes, thank you, Your Honor. Mr. Hendrickson, are you familiar with the lease between Wingate Apartments and Deodra Taylor?
Yes, I am.
And is the rent to retain possession for that apartment $1,730.99?
Yes, it is.
And that includes court costs of $157.
Yes.
Was this apartment kept in a reasonable state of repair and fit for the purposes intended?
Yes.
To the best of your knowledge, is this tenant under the age of 18 in the military or incompetent?
Not to my knowledge, no.
And have you received a sewer application from this tenant?
No.
Have you received a CDC declaration from this tenant?
No.
And you're asking that a possession judgment enter today?
Yes.
Thank you. No further questions, Your Honor.
All right, thank you, Mr. Grondike. I will allow a default judgment to enter in this matter for the amounts stated. There was a proposed judgment here. I filled in the amounts with a writ date of June 1, and we will get that entered and sent out to the parties.
Thank you, Your Honor.
Thank you. Anything further?
No, that's it. Have a good weekend.
Thanks, you as well.
Thank you. Bye.
Thank you, Your Honor.
Yep, goodbye. Mr. Florian, you're here for Hidden Lakes.
That is correct, Your Honor.
Well, let's wait. We'll give our 2 o'clock customers some time to appear, and then we'll call our cases.
Sounds good. Thank you.
All right, folks, we waited 15 minutes, but I don't see any new people except for the young lady who is sitting in my courtroom.
Your Honor, Stephanie McDowell has been calling Jennifer and Jen Lindsay, and she keeps getting disconnected, but she's been trying to get.
I think she's connected. Is that Miss McDowell? Stephanie McDowell on my Zoom screen? I'm getting some messages that she's been trying to call the clerk saying she got disconnected. Can you all hear me? Okay.
Yes.
Yes.
Yes. Okay. You guys were awfully quiet for a Zoom audience. Miss McDowell, can you hear me? I'll ask her to unmute. All right, Miss McDowell, there you go. You're unmuted. Can you hear me?
Yes.
All right, I got some messages that you were being disconnected, but it looks like you're connected just fine with me.
Yes.
Okay. All right, we are going to start with the matter here in the courtroom, though. The court is calling the case of River Oaks Apartments versus Shanice Green, case number 19-4439LT. Ma'am, can you come up to the lectern, please? Yes, right there to the lectern, to the microphone. Do I have an attorney here on behalf of River Oaks? All right, it wasn't until I saw that this was a 19 case that I realized we might have an issue. So let's see. This was scheduled for, oh ma'am, you're here a little early. You are here a little early, but you were here in the courtroom, so I thought we'd go ahead, but I guess I can't proceed on your case yet. I'm so sorry. Please have a seat. We'll wait and see if we get somebody here from River Oaks and jump the gun there. All right, the court is calling the case of Kellogg Cove Apartments versus Stephanie McDowell, case number 21-3406LT.
Good afternoon, Your Honor. My name is Matthew Miller, and I'm here on behalf of the Plaintiff Hughes Equity LLC 1, Kellogg Cove Apartments.
Mr. Miller, and then I know we have Ms. McDowell here as well. This is a termination of tenancy case. We did conduct the first hearing on May 14th. Ms. McDowell was here.
Yes.
And she appears again. Mr. Miller, how are you asking the court to proceed today?
I'm asking the court to enter judgment. There's no tribal issue of fact. By law, there can't be a tribal issue of fact. We issued a 30-day notice on January 13th, giving the defendant 90 days notice, in fact, to vacate by the end of the lease expiration, which was April 15th. She failed to do so. We filed this action. As a matter of law, there is no defense to such an action. We're asking the court to enter judgment with a writ date of June 1st.
Is there a money judgment requested in this matter?
No, Your Honor.
All right, Ms. McDowell, it does appear that your tenancy has ended in this matter. The pleadings are in order and the court will grant possession to the plaintiff. I did not hear an objection from you or assertion of
because
it.
I did not get the notice. I was trying to extend my lease or renew my lease. I didn't get a notice, and I didn't get a 90-day notice.
I literally mailed it personally myself from my office on January 13th.
And I called the corporate office and I got a verbal notice when I tried to extend my lease.
All right.
Well, when I tried to renew my lease. So it was verbal to me.
I see a notice to quit in the file. It's signed by Mr. Miller. It's dated, appears to be dated January 13th of this year.
Right.
It was sent to Ms. McDowell at 5340 Kellogg Woods Drive Southeast, number 205, which is the same address that the plaintiff is seeking possession of. And ma'am, you were here on May 14th, so you were aware last week when we were here of all of the facts and all of the allegations and all of the pleadings in this matter. The only reason we're having a second hearing is because of the CDC moratorium against evictions in light of the COVID-19 pandemic. All summary proceedings hearings initiated under the Landlord Tenant Act are required to have a second hearing, even termination of tenancy cases. And so you did have notice because you were here. And so the court is inclined to grant the termination at this time. Mr. Miller, I don't have any proposed judgment in my file.
Oh, that's unusual. Okay, well,
Well,
I can
if you
certainly,
sent one this week, it may not have gotten to me because Ms. Petrie has been on vacation. So if you sent it this week, it may be in her email. So
Judge, look at all the files I have at 2:30. Are we gonna have this problem for all of them?
likely.
Oh, no.
Okay, here's what we're going to do. We will enter this as a judgment of possession after hearing. Ms.
Where would-
McDowell, a copy
who
of
would-
that judgment will go out to you next week. I'm sorry, Mr.
To
Miller.
whom would you like me to send it if not to Jennifer, Your Honor?
No one. There's no one here to take it today via email. No one here to take it. So send it to Jennifer and we'll get it signed on Monday.
Okay, all right. Well, then I'll wait till the very end because there's obviously no rush at this point.
I'm sorry, there's no rush.
Okay, understood. Thank you, Your Honor.
Ms. McDowell, you
Yeah.
may see any remedy available to you under the law, but a judgment is going to enter. It will have a writ date of June 1st, correct, Mr. Miller? Because the 31st is a holiday.
Yes,
Yes.
June 1st is the first available date, Your Honor.
All right, thank you. Ms. McDowell, you may go. All right, the court is calling the case of Hidden Lakes Apartments versus Yama Peewee, case number 21-3407 LT. Counsel, your appearance for the record.
Jordan Florian on behalf of Hidden Lakes Apartments, P number 82253.
Good afternoon, Mr. Florian. I do not see anyone purporting to be Yama Peewee on my Zoom screen or in my courtroom. And I note that the tenant failed to appear at our first hearing on May 14th. How would you like the court to proceed today?
I'd like to seek the judgment of possession subject to payment of rent by June 1st.
All right, who do you have here on behalf of Hidden Lakes?
I believe it would be Melissa, I guess, Haight. I'm not sure if she's on though.
I don't see her.
I was told that she was going to be coming in today.
And she usually is. Let's see, this was a 2 o'clock matter, right?
Yes.
What I can do is I could give her a call.
Sure.
Okay, we'll go ahead. We'll move on, but we'll come back to this.
Okay.
Mm.
These are. I don't have any audio, so I'm going to attempt to call in. I'm sorry, I don't know if you can hear me or not.
Yes.
Oh, okay.
The court can hear you. Are you here on behalf of Hidden Lakes?
No, Walnut Hills.
Any luck, Mr. Florian?
I emailed my assistant. She said she's going to get a hold of her and see if she can get her in here.
Okay. All right. All right. The court's gonna recess for a moment. We'll be back shortly.
Thank you.
All right, I see Ms. Height has joined us. All right. We are back on the record then in 21-3407 LT, Hidden Lakes Apartments versus Yama Pee-wee. Plaintiff has requested a default judgment. Ms. Height, we need your testimony.
Sorry.
All right, can you raise your right hand, please? And do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Florian, you may inquire.
Mrs. Haight, can you please state your name and title for the record, please?
My name is Melissa Height, and I am the Assistant Property Manager for Hidden Lakes Apartments.
Thank you. Can you please confirm that Miss Yama Pee-wee is a current resident of Hidden Lakes Apartments?
She is.
Can you confirm that she is currently behind on rent, total monies due and costs totaling $1,479.59?
Yes.
And can you confirm that she has not made any CDC affidavits or other SARA fund applications?
They haven't to this date.
Okay, thank you.
All right, I have a proposed possession judgment in the amount of $1,479.59 with a writ date of May 31st. May 31st is a holiday, Mr. Florian, so we have to make that June 1.
That's fine, Your Honor. Thank you.
All right, the court will enter a possession judgment by default at this time. All right, and the court is calling the case of Hidden Lakes Apartments versus Wilfredo Valley, case number 21-3409 LT. Mr. Florian, you're here on this as well?
Yes, I am.
All right, and this is the second hearing. Defendant appeared on May 14th. Do I see Wilfredo Valley anywhere on my screen? Or who is appearing on phone number ending in 0623? Can you unmute and identify yourself? All right, well, it doesn't appear that Mr. Valley is here. Are you seeking a default judgment in this matter then, Mr. Florian?
Yes, I am, Your Honor.
Ms. Height, you are still under oath. You may inquire.
Hello, Mrs. Height. Can you please state your name and title again for the record, please?
Yes, it's Melissa Height, and I am the Assistant Property Manager for Hidden Lakes Apartments.
Can you please confirm that Wilfredo Valley is a current resident of the Hidden Valley 2 apartments?
He is.
Can you please confirm that his current rent to retain possession, other monies due, and costs total $3,281.10?
That is correct.
Can you please confirm whether or not Mr. Valley has provided a CDC affidavit or applied for any SARA funds or other funds for his rental?
He is not to my knowledge.
Thank you. And I think that's all I need. Thank you.
Ms. Height, to your knowledge, is Mr. Valley a minor, incompetent, or in the military?
No, he's not.
And has the premises been kept fit and habitable for human habitation and in reasonable repair?
Yes, it has.
All right, I will enter a default judgment in the amount of $3,281.10 with a written date of June 1.
Thank you, Your Honor.
All right, you are welcome. I think those are the only two for Hidden Lakes, correct?
Yes, thank you, Your Honor.
All right, thank you, Ms. Height. Have a nice weekend. Thank you, Mr. Florian.
Thank you.
All right, the court is recalling the matter of River Oaks Apartments versus Shanice Green, case number 19-4439 LT. You can come up to the lectern right here, ma'am. I jumped the gun, Mr. Henges, a few moments ago and called this case without you here.
Oh,
I'm glad to be here.
Apologies. All right. Mr. Hedges appears on behalf of River Oaks Apartments. You are Ms. Green?
Yes, ma'am.
All right. And this is your motion to set aside a default judgment entered November 4th of 2019. I did read what you submitted with your motion, but I'll give you the opportunity to just summarize for the court today or add any supplemental information, and then I'll hear Mr. Henge's argument, all right?
Thank you. Pretty much just during the time that everything was going on, I went to the property manager, or I think he was the assistant. I'm unaware, it was a man, I think his name was Evan. We spoke several times, and I also spoke to another woman in regards to kind of like my car getting vandalized and a little bit of everything. My car was getting vandalized, the screen on my apartment, like window was broken. It was just a lot going on. My child's father was murdered on Mother's Day of 2019, so May 12th. After that, it's just a whole bunch of things just started going on. I told her repeatedly, I filed a couple reports with the lead detective that was on the case for my child's father's murder at the time. And he just pretty much said to me that he didn't feel like it was safe for me to be there. And the man who murdered him at the time was out of mind. So once we spoke a few times, someone told me that I pretty much could vacate the premises, but I would have to like give them the reports and everything. And the detective told me that he sent everything to them for it. And I wasn't aware of that. I moved out of the residence like late September, if I'm not mistaken. I was not in the apartment during the time that they said that they served me the posting. That's why I said it was just posted. I never received anything. I wasn't aware of anything. I never was contacted, and they still have my contact number as well. I just literally found out that they filed for like eviction when I tried to apply for housing after I got done with all of my chemotherapy. I was going through stage 3 ovarian cancer. I just had a lot going on, like truly. I was in and out of the hospital from, I want to say, late September all the way up until maybe March, April-ish of 2020. And I have all my proper documentation for that. I was just had a lot going on, to be quite honest with you. As far as like the money judgment, I can try to make a way to pay for the money judgment. My biggest problem is the eviction that was filed. I'm not able to do anything with that eviction, especially when I wasn't aware of it at the time.
All right, Mr. Henges?
The same property manager that was working for River Oaks at that time remains there now. She's on this Zoom. She's got emails from the defendant in October of 2019 confirming that she understood that she was behind in rent. More than that, there's notes from the management computer system that the resident actually came in on October 30th before court and confirmed that she was aware of court. So I don't believe that and the information that was just relayed by the defendant is accurate. And I don't believe that this also was timely as a motion. It's more than 2 years later. I don't believe that there's been any showing required under the court rules to have such a motion filed more than a year later. And we did request that a money judgment enter for the amounts that would have entered at the time that the possession judgment entered. A money judgment was paid for. Personal service was not accomplished, but the defendant is now in the courtroom.
All right. And I'll note I'm looking at the original judgment here, and there was no judgment because they are not entitled to a money judgment if they don't get personal service, which they did not in this case. So there was only a possession judgment, but I recognize your position is that it is the judgment that prohibits you now from having, a clean record when you are seeking housing, and that it is prohibitive for you at this time, which puts you in a bad position. And it sounds to me as though you have had a few rough years.
And I'm not trying to, excuse me, I'm not trying to abandon my responsibilities. Prior to 2019, I was up on everything I had going on. I was in school, I was working 2 jobs, it's just I had a rough patch. And I never came to the office on the 30th and stated anything. I was in a hospital getting induced on the 29th of September for my daughter. I had to get back to her 2 months early due to my stage 3 cancer. So I never I just was unaware, and I was only communicating with my detective, and all of my people moved out of that apartment in September. If nothing was there, and I apologize to you guys, I didn't abandon the apartment, that's not what I do. I'm a single mother, and I've always been on my own. I've been living on my own since I was 18. I don't have anyone to help me. And now that I basically can't get a place to live in, and I have a 1-year-old, and we don't have anywhere safe to go because of the eviction. So it's not that I'm trying to abandon my responsibilities, it's just I was not aware of it. I never knew of it, and it just came to my attention. And the reason why I'm filing a year later is because I've been undergoing chemotherapy, and I have all of my documentations to prove it. I wasn't even in a state to take care of myself, let alone my daughter, so I wasn't able to pay attention to anything else. I was fighting for my life, and that's just as simple as I can put it. From blood clots, emergency blood transfusions, just a lot. I was undergoing heart problems, fluid on my heart. I had a preemie baby who was in NICU at the time. And of course, on the 4th, I wasn't able to be there because I gave birth to her November 2nd, and I was in the hospital from September all the way up until then. Like, it's just, I've been in and out, in and out, in and out.
You gave birth to your daughter on what day?
November 2nd. And I went to get induced on October 29th. I was scheduled supposed to happen on the 30th, but because she was 2 months early, they gave me a medicine to kind of induce the labor, as you can say, but it took longer than usual. But in September, when I moved out of the place in September, I was in the hospital as well. I have a full letter from my high chart that kind of like sums up a little bit of like my in and out, but I was in and out of the hospital so many times, like honestly, from the time I was a high risk pregnancy as well. So it's kind of unbelievable how much I was in and out of the hospital. Like I was in the hospital like crazy. And it stayed free it was about 11 days in bed, and I had to undergo a surgery while I was pregnant with her as well.
Ma'am, I am sympathetic to your circumstances at that time. It sounds awful. And I am certain that this got pushed to the wayside. Can't grant your motion today because you haven't alleged any grounds that are required under the court rules for setting aside a motion, because there are only a certain number of criteria that allow a valid judgment to be set aside, and you have not alleged any of them. While what you have alleged sounds traumatic, it doesn't meet the legal burden for me to set it aside, but I will deny your motion without prejudice, which means if you seek legal assistance or are able to allege grounds sufficient for the court to set it aside, you may bring your motion again before this court without penalty. I'm also going to ask Mr. Henges to have a conversation with you. I'm going to allow you a private conversation period of time to discuss. They wanted a money judgment at one point. They didn't get it. Perhaps there's a settlement, Mr. Henges, to be had that includes a voluntary setting aside with a payment plan. If you have authority to negotiate that on behalf of your client, you have Ms. Green here with the opportunity to have that conversation. For today, though, ma'am, your motion is denied. I'm going to ask you to go out of the courtroom to the left. To the left again, there's a conference room there. There's a laptop in it. I'm going to move Mr. Henges into a breakout room so that he can meet with you privately. You can discuss potentially a voluntary agreement to set it aside, but the court is denying your motion today. All right. Mr. Henges, do you have other landlords on the docket this afternoon?
No, Judge. I would also need Sarah from River Oaks. She's on the Zoom.
All right. And I will place Sarah, Ms. Kosian. I don't think we've met before.
We haven't. It's Koshin.
Koshin. I'll place Ms. Koshin, Mr. Henges in the breakout room, and then my deputy will show you into the conference floor. You're welcome. All right, Mr. Walton, you were here and then you were gone again. All right, the court is calling the case of Woodland Creek Apartments versus Kyle Walton, case number 21-3308 LT. Counsel, your appearance for the record.
Good afternoon again, Your Honor. My name is Matthew Miller. I'm here on behalf of the plaintiff, Woodland Creek Apartments.
Good afternoon, Mr. Miller. And you are Mr. Walton? I'll have you unmute, sir.
Oh, yes. Good morning, Judge.
All right, it's afternoon, which means we're inching closer to 5 o'clock.
Oh, well, good afternoon.
All right. In reviewing the file, this court notes that we've had 2 prior hearings in this matter. The first was a pretrial on April 2nd. We set it for the mandatory second pretrial. That was held on April 9th, whereupon Mr. Walton advised this court he had applied for SARA funding, which mandated a 30-day stay at minimum on proceedings in this matter. And this was one of those first cases that the court was executing SARA stays on. And so we set this not for 45 days out, as the court has lately been doing, but only 30 days out. And so in reviewing AO 2020-17, by this date, we need to know whether or not there's been an eligibility determination made by HARA. Mr. Miller, are you able to update the court on this?
I have no idea, Your Honor. What I do know is that this is actually the 4th hearing, not the 3rd hearing, because it was April 2nd, April 9th, then the adjournment to May 3rd, which was 30 days from the initial hearing, and now another 2.5 weeks have now since gone by. So the 30 days are gone, the 45 days are gone.
Oh,
It's all gone.
Right. I see the May 3rd date in here. You're correct. We are 45 days out. I'm not great at math on the spot, especially when we're talking about months that have 30, 31, 28 days, but you are correct. So we are 45 days out from the initial pretrial in this matter. Ms. Schofield, maybe you can update us.
We submitted everything that the SARA needed. We just haven't heard anything in regard to approval or if they needed anything else from us or anything. It's been a struggle for all of my residents trying to get answers.
Yeah.
And so pursuant to the order, the stay of proceedings is contingent upon the following events. A, an eligibility determination is made by the appropriate HARA within 30 days of the pretrial hearing. B, the defendant is eligible to receive rental assistance for all rent owed. And C, the plaintiff receives full payment from the SARA program within 45 days of the pretrial hearing. If any of these events do not occur, excluding delays attributable to the plaintiff, the court must lift the stay and continue with proceedings. I don't see contemplated in this order what to do if SARA doesn't take the first step, which is to make that initial determination of eligibility for or against the tenant.
I was just wondering, Your Honor, if Ms. Hampshire might have some secret in on maybe what the status of Mr. Walton's application might be. I know it's not her agency, but maybe she's got like a special secret contact.
So I have access to the SARA website where I can see if someone has filed an application, and I can see that he has one in process, but I cannot see where it's at in the process or even who it's assigned to, unfortunately.
The caseworker requested that I mail my pay stubs, which I did electronically, and I'm just waiting for a confirmation of whether or not I get approved still. So it's still in process of determination.
You know, it's interesting, Mr. Walton. I don't know where the other defendant is, but Mr. Walton doesn't have a particularly large balance. You know, he's been making payments all along. I mean, sir, if I don't know if you even need or qualify for Sarah? Because it seems like you must be working because you have been making payments, right?
Well, I've been trying to continue to make payments while waiting for a response of whether or not I will be able to receive some assistance, because I am having a hard time doing that.
All right, at this time, the court finds that pursuant to this order, the stay in proceedings must be lifted, which places us in a position where a judgment may enter. I don't have an updated statement of rent, and so, Mr. Miller, I'd suggest we have some testimony from Ms. Schofield regarding
Absolutely.
regarding those pieces of information, if indeed you are seeking a judgment to enter today.
No, I think it's appropriate. And I also would say, and maybe Kelly can jump in if she disagrees with me, but that if Mr. Walton gets confirmation from Sarah that the money is coming, I can't imagine that they're going to pursue his removal with the money on the way. We just need to, maybe getting them the judgment will inspire them to move a little with more urgency. I don't know.
It's outside the court's purview, but I have heard from attorneys that in other places in the state, the money is coming through fluently, but not here. So
it varies widely from county to county, Your Honor. It really does.
Yeah, I've only had like 2 approvals and I have like 13, 14 Sarah applications pending. It's been quite a journey, quite a frustrating time.
I think what all parties are saying is that there are a lot of pieces outside of our immediate control in this, and the frustration is real, both on your part and on the part of your landlord, as well as the attorneys who are paid to spend their time coming back and hearing that we don't have a resolution yet at this point. As Mr. Miller is pointing out, that we've been here 3 times already. And so, Ms. Schofield, I think I will swear you in. I will let Mr. Miller inquire as to the rents due, and then we'll proceed. Can you raise your right hand?
Mhm.
All right. And do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Miller, you may inquire.
Ma'am, will you please state your name for the record?
Kelly Schofield?
And are you familiar with the books and records of Woodland Creek Apartments?
Yes.
Is the current amount of rent due and owing by Mr. Walton and the co-tenant Philippe Gober $1,271.21?
That's correct.
Has this apartment been kept in reasonable repair and fit for human
Yes.
habitation? Is Mr. Walton or Mr. Gober in the military service a minor or incompetent?
No.
Your Honor, we're seeking costs today of $151 for a total of $1,422.21 with an order of eviction to issue after June 1st if not paid.
Actually, I think the court costs are 171. Did you say 171 or 151?
No, I said 151, but I certainly could be wrong. I've been wrong plenty of times in the past. Let me redo the math real fast. Hold on.
Yeah, 171 is the court cost.
Your Honor, I have 41 for service. Is that what the court shows?
Yes.
Yeah, it is 171. Sorry. You're correct. 171. So that would make the total 1,442.21. Thank you, Kelly.
Mm-hmm.
All right, Mr. Walton, the court is entering judgment today in the amount of $1,442.21. You will have 10 days to pay the rent, to move, or to appeal this court's decision. But as you heard in the discussion prior to the entry of this judgment, no one wants to abandon the money if it's on the way. And so just keep in touch with Ms. Schofield as to whether or not there's money to be had. You've gotten approval. Ms. Schofield, of course, will be watching out for the approval and the eligibility determination from Sarah. But this court is unable to continue rescheduling based on the language of this order and based on the nature of summary proceedings at this point. And so, Mr. Miller, I'll have you provide a judgment for entry. I don't have one.
I will certainly, Your Honor. And I would just remind Mr. Walton that when he receives the judgment, the first thing he should do is email it to whomever he was dealing with at the HARA to let them know that it's out there, because maybe that will kick you to the top of the list and inspire some action. Okay?
Excuse me?
Yes.
Yes. I'm hoping that you all will be able to like grant me till the 5th, because I'm pretty sure I'll have the rest of the balance.
Well, how about this? Just stay in contact with Ms. Schofield, let her know what's going on, and we'll cross that bridge when we get to the 1st. But remember, come the 1st, June rent's going to come due too. So keep that in mind.
Right.
I
Okay.
might be able to offer an alternate solution here. He could apply with me for state emergency relief, and I only have 15 days to process from start to finish. So in the meantime, I might be able to get him approved for at least a portion of what he still needs to make it more within his grasp.
All right.
Oh, yeah.
No, I mean, I can't imagine. I see Mr. Miller shaking his head. I can't imagine that Ms. Schofield would object to that.
No, we hate Helen's money. We hate Helen and her money.
All right, then the court is going to enter the judgment as already stated, but Mr. Walton, I'm going to place you into a breakout room now with Ms. Hampshire, who can assist you in a separate application for additional funds. And then again, you must keep in contact with Ms. Schofield. They won't turn down the money, I promise. So anything further on this matter then, Mr. Miller?
No, thank you, Your Honor.
All right.
So I had to June 1st right now?
Yes. Watch your screen, Mr. Walton. There's an invitation for you to join Ms. Hampshire.
Thank you, Judge. Thank you, everyone.
You're welcome.
Good luck.
Yes, good luck.
Okay.
Okay. All right, the court is calling the case of Woodbridge Apartments versus Tamara Lovegrove, case number 21-3369 LT. You can come right up here to the lectern, ma'am. This matter was set for again, a multiple hearing in this matter. It looks like we were here on May 3rd, May 10th, and we set it out for May 21. I wonder if that is because you didn't appear the first hearing, ma'am.
There was a Zoom meeting, I was unable to.
All right. Well, the last information I have is that rent to retain possession at that time was $3,599.03. That was at the beginning of May. All right, is there any update on this matter, Mr. Miller?
Not that I'm aware of, unless Ms. Lovegrove has information, and I'm wondering if Mr. May is planning to join us today.
He is not, but I did submit an application for Sarah. I haven't received word back, but they said they would send me an email as well.
All right.
So that should be automatic email.
So she did apply for Sarah.
Do we know when?
It was early this week. I had not gave information, but it asked about unemployment information, eligibility, and other documents that I had to send in or email him.
Who is the manager for Woodbridge? Who's here on behalf of Woodbridge?
Ms. Schofield again, Your Honor.
All right. And have you received information of a Sarah application in this matter?
We did receive that she submitted her application, and then we also submitted our portion, but we have not heard anything back.
So this, Your Honor, might actually be ripe for another short adjournment, I would think.
I think you're right, Mr. Miller. It is right, but it begs the question, of course, right? The order states that in cases filed for non-payment of rent, a court must stay further proceedings after the pretrial hearing is conducted if the tenant applies for Sarah and notifies the court. So she's notifying the court today that just a couple of days ago she applied for Sarah, but our first pretrial date was May 3rd in this matter. So the court interprets this order that if an eligibility determination is not made then by approximately June 3rd, which would be our 30 days, we've failed the first marker in the 3 criteria required to continue a stay of proceedings. Mr. Miller, do you disagree?
I don't disagree, Your Honor. That's why I think we should probably adjourn it to a date after June 3rd. I think you're right.
Let's do this. And I don't have Jennifer here with her pre-mathematically calculated dates, but May 3rd,
Hold
June,
on.
we'll set it out. Well, and I can't tell you what, she manages the schedule. We'll set that out for 45 days from May 3rd for a last hearing in this matter. Ma'am, by that point, as you just heard with Mr. Walton, if we don't have all of the elements necessary, this matter will be appropriate for a judgment to enter if there is still money due and owing. Do you understand? The delay in filing for Sarah puts you at a disadvantage, which is unfortunate, but it is the way the order is written.
So you'll not be able to give us a date because Jennifer's not there. We'll just have to wait for the notice to come for sometime in June. I got it. I just want to make sure.
We just, yeah.
I gotcha. Thank you, Your Honor.
Mm-hmm. We'll generate a notice and send it out.
Understood.
I think they call that job security for Jennifer. All right, ma'am, you may go. We'll schedule another hearing date and we'll get it out to the mail for you. I wish you the best. All right, we'll see you back here in a few weeks. That notice of date and time will come in the mail. Thank you. All right, the court is calling the case of Walnut Hills Apartments versus Danita Chapman, case number 21-3276LT. I see Ms. Chapman.
Yes.
Can you hear me?
Yes, I can.
All right, and this matter has had a number of prior hearings as well. April 9th, May 3rd, which I think means then that we are at our 45-day mark.
Yes.
You had applied for Sarah.
Yes, I did.
I'm sorry, what is your name?
Danita Chapman.
No, the manager who is here on Walnut Hills.
Hi, Judge. Stacy Orr for Walnut Hills.
All right, Miss Orr, do you have any information on this?
I have her balance and her ledger here.
But you have no information that, I mean, you can't tell me that you've received Sarah funding for her?
No, we have not received any funding.
But you filed your piece and the application is ongoing?
I filed my piece, and when I talked to the Salvation Army 2 days ago, they told me that they were still waiting for the application from my apartment complex to come in still. They said that they contacted them over a week ago regarding it.
Is this, wait a second, I'm confused here. Isn't there a termination matter against Ms. Chapman? Or am I just making that up? Because the name sounds very familiar to me. Do we have a separate action?
This is a non-payment of rent complaint.
I know this is, but I was asking Ms. Orr if she knew. Let me just see.
I don't believe so, Matt.
Oh, no? Okay. All right.
In my system,
No, I guess not.
I don't see one. All right, so Ms. Orr, we were here on April 9th, and at that point, that is when Ms. Chapman indicated to us that she had applied for Sarah and filled in her application. But there is, to my understanding, there's a piece then required from the landlord. Have you sent that in?
We've sent everything that they've asked us to send.
All right. And so, Ms. Chapman, you were just saying that to your knowledge, they were still waiting on information from the landlord?
Yes, I got an email on Wednesday from my caseworker with the Salvation Army saying as such. They're still waiting for some paperwork to come in.
From you or from
Walnut Hills?
Wednesday the 19th?
Wednesday the 19th.
Ms. Orr, are you able to just double check and verify?
Yeah, let me double check, Judge.
I will say this though, Your Honor, and I don't know if this has any real bearing, but the defendant received, my client received on behalf of the defendant more than $8,000 in a rent payment from Salvation Army back in January. And she hasn't made a payment at all since. So I don't know. I mean, you know, obviously the program is different. Maybe she still qualifies. I don't know. But, you know, I don't know if they're going to hold that $8,000 against her and not pay this because she's got another over $4,000 balance. But I don't know. Maybe they will, maybe they won't. I'm not sure.
I'm gonna wait to hear from Ms. Orr, and then we'll decide what we do.
Yes, it looks like someone by the name of Monica Morris reached out regarding a W-9 this week, which has been sent. I'm looking at confirmation that we have sent everything.
Okay. All right, Mr. Miller, how are you asking the court to proceed?
I think we should enter judgment, and I think that we should suggest that Ms. Chapman take that judgment to her caseworker, and hopefully that expedites the proceedings.
I think that is, given that the first pretrial hearing was conducted in this matter on April 2nd, and that on April 9th, we were advised of the Sarah application, it's been quite some time. Yes. I think that's probably appropriate. And so, Ms. Orr, I'm going to have you give testimony on what is currently due and owing. Can you raise your right hand? And do you swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
Mr. Miller, you may inquire.
Thank you. Stacy, will you please state your name for the record?
Stacy Orr.
And are you familiar with the books and records at Walnut Hills Apartments?
Yes.
And is the current amount of rent due and owing by Danita Chapman at 4155 Nature Trail Southeast, Apartment 11, $4,153?
That's correct.
Has this apartment kept in reasonable repair and fit for human habitation?
Yes.
Is this defendant in the military service a minor or incompetent?
No.
Your Honor, we're seeking costs today in the amount of $206 and for a possession and a money judgment at this time.
What was the rent to retain possession?
4153. 206 was the cost. The total is 4359.
And I do see that there was a complaint for money judgment filed as well.
Yes.
Ms. Chapman, I do find it appropriate to enter a judgment of possession in this matter today. It will enter for $4,359, which means you have 10 days to pay the rent, to move, or to appeal this court's decision. My recommendation to you is to keep in contact with Ms. Orr and with the management at Walnut Hills. If the funding comes in, I'm certain they will not turn it away, and then this matter will be resolved. Again, keep in contact with them and make sure you've provided everything that is necessary. Anything further in this matter, Mr. Miller?
No, thank you, Your Honor.
All right. All right, Ms. Chapman, you may go. right, I have a couple of people appearing on my screen with phone numbers. One ends in 0623. Can you unmute and identify yourself, please? Or the other number ending in 5714. If you could unmute and identify yourself for the court, please. 5714 tried to unmute, but then I was doing it at the same time and accidentally muted them back. 5714, if you could unmute, please.
Kenesha Johnson.
Kenesha Johnson. All right. The court is calling the case of Breton Court Apartments versus Kenesha Johnson, case number 21-3413 LT. Mr. Miller, are you here on behalf of Breton Court?
Yes, Your Honor. Good afternoon. I'm Matthew Miller on behalf of the plaintiff, Breton Court Apartments. I'm joined by the manager, James Bollinger.
Thank you. And Ms. Johnson joins us via phone. This is set for the second of two landlord-tenant hearings in a summary proceeding to recover possession of property for non-payment of rent. I don't have any notes that Ms. Johnson appeared at the first hearing.
My notes reflect she did, Your Honor.
She did? Okay. Well, that's good. What I do have from the first hearing is that rent to retain possession was $2,292. She must not have contested if she was here, or else I certainly would have had notes. And so,
Your Honor, I think she was here and then she had to leave to go to work. That's why she was here. You noticed her, and then she disappeared. Now she's back. That was last week.
Okay, well, she's here now. So let's see. Let's go back. Ms. Johnson, then the court was provided information that total rent to retain possession is $2,286, including $206 in court costs. The landlord is seeking a possession judgment of $2,592. Do you have any reason to believe that those numbers are incorrect?
No, just correct.
All right. And is there a reason that you haven't paid other than just not having the money right now?
Other than I had to take my daughter out of school and I had to deal with her virtually. And I stopped working for a little while due to her one of her peers caught COVID and she had to quarantine, so I had to pull her out of school.
So you weren't able to work, so you didn't have the money. That's why you didn't pay?
That's correct.
All right. Are you applying for any assistance, financial assistance?
I applied to DHS, which they are willing to do a portion. I applied to Sarah, which I am still waiting for them to let me know it's still pending.
When did you apply for Sarah, Ms. Johnson?
May 3rd.
The 3rd of this month?
Yeah.
All right. We were here on 5/14. So we need a date 45 days from May 14. All right, ma'am, we're going to stay proceedings in this matter to find out what happens with your Sarah application. We're going to set for a hearing approximately 45 days after the original date in this matter, which was 5/14.
Okay.
At that time, either your Sarah funding should have come in, or we will be in a position of judgment.
I called Salvation Army and they told me that it's going to take a little minute. They have a lot of applications, but she did tell me to check the thing, and I did, but it's still pending. So, I mean, I'm waiting on them.
Well, keep in touch with them. Keep in touch with your landlord. That's why we're setting it out, so that for the time period is necessary for those approvals to come in. All right, we'll generate that notice. I can't give you the date and time today, but we'll get it out in the mail next week.
Very good. Thank you, Your Honor.
You're welcome, Mr. Miller. All right, phone number ending in 0623. Ms. Johnson, you may go. I can't help you if I don't know who you are, so I need you to unmute and identify yourself for the court, please. Unless Mr. Bollinger is able to identify that number.
Your Honor, I think it is Leroy Brown Figures.
All right, Mr. Brown Figures, if you can hear me, I can't hear you, and I can't see you, and I can't help you unless you unmute and identify yourself for the court, please.
Actually, James, according to your ledger, that's not his cell number. He's got a.
Then it might be Sterkenburg Miller then.
Thanks.
I only have 2 left.
Well, I have.
He's off.
Somebody's talking.
Oh, hi. What's your name?
I'm sorry. I'm Centavia. I didn't know how to unmute it when I was calling.
Well, got one. We're ready to go.
Yes. Although, are you outside, ma'am? Because there's quite a bit of background noise, like wind noise.
Okay. I was outside. It was people in the house. It's kind of loud in the house.
Yeah. Okay. The court is calling the case of Brettoncourt Apartments versus Centavia Miller, case number 21-3386LT.
Your Honor, again, this is Matthew Miller. I'm here on behalf of the plaintiff, joined by my client's manager, Mr. Bollinger.
Thank you. And I do have Ms. Miller available by phone. She's here. She has called into the Zoom app through the phone. This matter has had a couple of hearings already. Mr. Bollinger, is that because there's a SARA application?
I actually think it's a CDC form.
Well, at the last hearing, Your Honor, on May 10th, May 10th, my notes are that Ms. Miller had reported that she was applying for assistance, but had not yet done so at that time. So I don't know if she has to date.
Nope, that's correct. I had no access to internet. It just got cut back on today. So I was going to do it today after court. I've still been dealing with my daughter with the COVID, and we're confined in the house. So we really can't leave. I just had to step out the house for a minute to get on the phone with you guys.
So you have not yet applied for SARA rental assistance?
No, ma'am. But any type of portion that I have to pay, I will pay my portion. Even if they don't pay a portion, it'll still get paid because I need a place to live for my girls and my son.
Yeah. Your Honor, just to bring everybody up to speed, right now I have the balance as $1,156.22, including costs. She made a payment a few weeks ago, so she has been making an effort. This might be somebody that Helen should speak to because she may only need a portion to get herself caught up.
Well, I think that's an excellent idea, Mr. Miller. So maybe what the court is inclined to do is adjourn this one more time and give her the opportunity to speak with Ms. Hampshire and see about assistance.
Okay. When were you thinking about having us return, Your Honor?
Well, you know what? Let's do this. Ms. Miller, I recognize the technological challenges associated with calling into Zoom, but I think what I'd like you to do is meet with Ms. Hampshire, who can pre-screen you and determine whether or not it looks as though DHS can help you. And then I want you to, because you're on a phone and you haven't video called in, you won't be able to come back to the court's Zoom room. So I'm going to need you to call back in after you talk with Ms. Hampshire. Can you do that for me?
Yes.
All right. So you'll be moved into a breakout room where you can have a conversation with her, but you won't be able to come back. You'll have to disconnect and call again. So let's do that. Let's get that preliminary pre-screening before we decide if and when we're going to adjourn.
Okay.
All right.
And then I think then the only person we're still waiting on is the phantom Mr. Brown Figures that Mr. Bollinger thought was here, but is not. So
Miss
I
Hampshire,
guess,
hold on, Miss Hampshire, I see Mr. Walton is still in the breakout room.
I told him he could leave.
Well, remind him he can go if you get.
Okay. I even emailed him already. I'll go see what he's up to.
All right.
Thanks.
Yep. What about, so you have Mr. Brown figures, but what about Gregory Davis?
who's the landlord, Your Honor?
It's Hunter's Ridge.
I don't show that, so I'm guessing that, let me just check, I'm guessing that's, yeah, that's, presumably that's a dismissal, Your Honor, because I don't have the file for that, so.
Let me pull up the.
You see that it's, I do see that it's up to date, so it's probably a dismissal, Your Honor.
I don't have, well, but again, Jennifer is on vacation. So I don't have any notes in the ROA that say something along the lines of received dismissal or adjourn pending dismissal.
Yeah.
But that's
Well,
what
I can confirm that in like a minute while the other things are going on, Your Honor.
I guess you didn't realize how important Jennifer is in this whole thing going on, right?
No, I know exactly how important Jennifer is. I really get it just stops without her. I mean,
Makes sense.
so valuable. Nancy, what?
Mr. Leroy Brown figures was in Zoom for a while.
Oh.
Because I've highlighted his name that he was here. I
My-
don't know where he went.
My court reporter is telling me that she saw Mr. Brown figures amongst the faces on the Zoom waiting on the Zoom screen at some
He
point.
was, Your Honor, and with us being a little behind, I think he had to go. I've been texting back and forth. So he did file a SERA application this past Monday already, so.